My name is Michael Beaumont, National Chairperson of Action SA. Yesterday, Action SA filed papers in the North Gauteng High Court to compel the IEC to provide its record of decision when it refused to investigate the ANC's 102 million rand settlement with Isolweni Investments. Action SA's concern is that this settlement agreement could not be compliant with the Party Funding Act, given at the time the ANC was unable to pay the salaries of striking workers outside of their gates, and that they had only disclosed donations in the amount of 10 million rand in the period immediately before that agreement. Now, any rational person knows you can't settle 102 million rands worth of debt with 10 million rand, and certainly not legally. The IEC as an institution is compelled to provide a rational basis for its decision-making, and when Action SA gets that record of decision through the courts, we will be determining whether or not there was a rational basis for that decision. Because South Africans need to know if political parties are receiving illicit funding in the funding of their campaigns, and South Africans certainly need to know that they are not paying for these debt settlements agreements, because Action SA has proven already that Isolweni Investments is a supplier to the state in at least one municipality in KZN, where it has won tenders worth millions of rands in the provision of services. Action SA believes the fight for party funding compliance requires political parties to hold the IEC to account to investigate these issues. It is not enough for them to say the complainant must prove the case for them. They have obligations of their own, and they must investigate these matters as well. Because ultimately, Action SA wants to ensure that all political parties are adhering to the Party Funding Act provisions, and not just ourselves, so that we compete on an even and an honest and a transparent footing when it comes to elections.